If someone close to you has recently passed away, the distribution of their estate may be part of settling their affairs. Depending on the situation, it may be necessary to probate their estate, meaning the assets that they left behind. Unless you are an attorney or a court official yourself, it is likely that the Utah probate system is unfamiliar to you. This can seem confusing, but understanding a little bit about what probate is and when it is necessary can really help you determine whether or not it is a necessary legal process for you in your personal situation. So what is probate? In simple terms, probate is the legal process of proving a will's validity in court. Or, if there is no will, it's the effect of giving someone else who's living the authority to sign the deceased person's name and administer their affairs after they have passed away. It is important when determining how the decedent's assets will be distributed through the probate process. It grants the executor, or what we call in Utah, the personal representative of the estate, the ability to enact and enforce a will, or through the Utah Code, administer that person's assets after they're gone. You see, through probate, you get legal permission to do what the will says or what the Utah Code says. Probate may also include appraising assets, paying debts, paying taxes, and distributing assets to either the heirs or to the beneficiaries under the terms of the will. However, probate isn't always necessary. The conditions depend on the state, and in Utah, there are many ways to avoid having to go through probate. Discussing your options with a lawyer is always the best way to know whether or not probate is necessary after someone has passed away. So how does probate work? Well, first and foremost, there are two kinds of probate court processes in Utah. There's a formal court process and there's an informal court process. An informal probate is used when the beneficiaries of the will are generally in agreement with what's going to happen. The informal probate does not require a judge to settle any disputes, and it doesn't require any court hearings. Everything can be done administratively through your attorney's office. It's also less expensive. So you should always choose an informal probate when people are generally in agreement and there's not going to be a lot of fighting, what we would call an uncontested proceeding. A formal probate, however, is the process when beneficiaries are unable to agree, or perhaps one person thinks something is unfair, or there's going to be what we call a will contest, meaning someone's going to contest the terms of the will or how things are going to be distributed and administered. This would require a formal court setting in order to settle disputes, and there will be court hearings involved. After deciding which process to use, the probate is then opened by the personal representative or executor by an application or a petition for probate and appointment of personal representative. This stage in the process is the beginning. It's when the personal representative asks the court to appoint them to be in charge of the estate. Once the hearing takes place in a formal or the time has passed in an informal, the court will sign the order or the statement of probate, which will allow that person who's appointed as the personal representative to act on behalf of the estate. The other documents that are issued are called either letters testamentary or letters of administration. Letters testamentary are a one-page court document that say you have the power to administer the will according to the terms of the will. The letters of administration say the same thing, except for they say, because there is no will, they say you are able to effectually administer the estate of the person who's died according to the Utah Probate Code. So, what do you do now? Probate can be a long, expensive, confusing process, and sometimes it can be avoided, especially if you have an estate plan in place or a revocable living trust. If those were created and funded prior to the decedent's demise, then you can most likely avoid probate. If you did not, or that person did not, then steps need to be taken to administer the estate through the probate process. For more information about probate proceedings in the state of Utah and what your options are, be sure to call the law firm of Ascent Law, 801-676-5506, and speak with a competent Utah attorney who regularly practices in this area of law. Go ahead and give us a call, 801-676-5506. Thanks for watching.